But I want to ask you for a moment, I can, about some troubling reports that a prosecutor from your office, Jay Bratt, implied to Stanley Woodward that the administration would look more favorably on a judgeship application if he managed to get his client, Walt Nauta, to cooperate against President Trump and to flip on him. My question for you, is this appropriate behavior for a special counsel's office to leverage attorneys' future career prospects? Again, to say that you didn't consider it to be credible, I guess we have the United States Associate Attorney General, Stanley Woodward, who claims that this threat was made to him, and I don't see what he would stand to gain from not telling the truth there. And thank you, Mr. Chairman. Mr. Smith, we've heard a lot of information that's gone across this day as we spin it here. We've heard disregard for the First Amendment at times. We've heard talk about solely seeking charges against Donald Trump, obviously targeting. We've talked about the amount of time and reasonable time frame. But I want to ask you for a moment, I can, about some troubling reports that a prosecutor from your office, Jay Bratt, implied to Stanley Woodward that the administration would look more favorably on a judgeship application if he managed to get his client, Walt Nauta, to cooperate against President Trump and to flip on him. And we know this because Stanley Woodward himself came forth with this information. And I guess my question for you, is this appropriate behavior for a special counsel's office to leverage attorneys' future career prospects?
Sir, I believe I can answer this question, even though it's regarding the Florida case, because we did filings on it, and I'm not referring to anything in the final report. And my answer to you, sir, is that when I was first notified about this issue, which was 9 months after it allegedly occurred, this is alleged to have occurred before I was even special counsel, what I did is I directed my deputies to look into it. We made sure the person involved self-referred it to OPR, and then we did a filing to the court. There was a motion by President Trump's attorneys. We responded and we laid out our position, and our position was that I did not believe that that allegation was credible. At best, it was a misunderstanding because the people in the room did not understand any threat to be made. Even Mr. Woodward, in his allegation, claimed it was only an inference. 9 months went by where we interacted with Mr. Woodward, in which we had no hearing of a complaint. When the complaint was raised for the first time, which was on the eve of that indictment being brought, it was raised in the guise of asking the court to delay the indictment while an investigation of it happened. So I take allegations of misconduct very seriously. I would not want any of my attorneys threatening anybody. Ultimately, when I looked at this, I did not credit it, and we responded with our position in court. But we also, it was clear that it was referred to the Office of Professional Responsibility, which is what good prosecutors do in that situation.
Well, again, to say that you didn't consider it to be credible, I guess we have the United States Associate Attorney General, Stanley Woodward, who claims that this threat was made to him, and I don't see what he would stand to gain from not telling the truth there. And I understand that you tasked 2 of your attorneys with investigating those statements made by Bratt, but given the amount of publicity and the scrutiny that was surrounding this entire investigation, why in the world did you not initiate an independent investigation into these very alarming allegations?
Well, 2 points there. You stated that you don't, why would he do this? When he made the allegation, when this allegation first came from President Trump's attorneys and then days later from Mr. Woodward, he did ask for the case, the indictment, to be put off in result of this. So there was a thing he was asking for in result. And with respect to an independent investigation, that's exactly why you refer this to the Office of Professional Responsibility. They conduct an independent investigation outside of my office.
Well, let me just say, for 4 years, we watched the Biden administration politicize and weaponize the Department of Justice. From going after pro-life activists to spying on faithful Catholics, the Biden administration showed disregard for impartiality. And this blatant disregard was perhaps no clearer than in the targeting of President Trump. We've talked about it all throughout this day. They knew they couldn't beat him at the ballot box, so they pursued alternative options. And I'm grateful for this committee's efforts today to investigate this conduct to ensure accountability. And while elections are not akin to jury trials, I feel strongly that the results of the 2024 election sent a clear message about how the American people feel about these politicized charges. And I think they absolutely made a difference in those 24 elections. And with that, Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from Missouri.
Mr. Chair, I actually have a UC.
Gentleman is recognized.
This is, let's see, I asked unanimous consent to enter into the record this DOJ press release titled "Houston Man Sentenced to Prison for Assaulting Law Enforcement with Dangerous Weapons During January 6th Capitol Breach."
Without objection.
My second one is I asked unanimous consent to enter into the record an article titled "They Ransacked the U.S. Capitol and Want the Government to Pay Them Back," published by the Washington Post, January 21st, 2026.
Without objection. Gentleman from Missouri is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Smith, after indicting the leading Republican candidate for the President of the United States on August 1st, 2023, you asked for a trial date of January 2024, just 5 months later. During your deposition, you did not dispute that that would have given Trump's legal team just 5 months to review 13 million pages and thousands of hours of video evidence, working out to nearly 100,000 pages per day. Mr. Smith, you claim that you acted independently of the upcoming presidential election, and yet you pushed for a trial date ahead of the election. Why such a rush to charge and try and pursue conviction on President Trump?
I sought to move that case forward expeditiously because the public has a right to a speedy trial as well as a defendant. That is, there is Supreme Court precedent directly on point regarding that. I felt it was my duty to do that. I considered all options. I listened to
But isn't the right to a speedy trial primarily a right of the defendant? I honestly, before your arguments, I've never heard of the idea that the prosecution has a right to speed up a trial and require the defense to review 100,000 pages a day in order to get a trial in before an election. I've never heard of such a thing.
The Supreme Court, in at least, as I sit here now, 3 different cases, has stated pretty explicitly that the right to a speedy trial is the public's as well as the defendant's, and that
You were trying to get President tried, convicted, and hopefully in prison before Election Day. I understand, Mr. Smith. I think it's very telling that during your deposition you could not articulate any evidence that President Trump instructed individuals to unlawfully enter the Capitol on January 6, 2021. You claim that President Trump was, quote, responsible for the events at the Capitol on January 6th, which was not charged in your indictment. How do you reconcile that with the position of the department in other GA6 related cases that President Trump wasn't responsible for the events at the Capitol that day?
I'm not aware of the department taking a position that Donald Trump was not responsible. I think my recollection is the position that the department took in other cases is other defendants weren't not responsible themselves because of Donald Trump, that blaming him wasn't going to be a valid defense in their case. That's my recollection.